The next case to come before the court is Josanne Aungst versus Mark Light et al. Each side will have 15 minutes to present your arguments. Appellant may reserve up to 5 minutes for rebuttal if you wish to do so. 5 minutes or less than that. Let me know when you take the podium. I'll do my best to monitor the time and try to keep you apprised of how much time you have left. The matter is being visually and audibly recorded, so please stay behind the podium and keep your voice up. And who is going to be proceeding for the appellant?
I will be on that.
All right, go ahead. Whenever you're ready.
May it please the court, I'm Albert Chen with the law firm of Botini and Botini in San Diego. I'm arguing this appeal on behalf of plaintiff appellant Josanne Aungst. I will reserve 5 minutes for rebuttal.
Thank you.
Thank you. We raised 2 assignments of errors in this appeal. The first one is that the trial court misapplied the distinctive independent exception to the rule of false versus hard. The second is that the trial court erroneously denied leave to amend. My client only filed 1 complaint. This is an initial complaint with a first motion dismissed. And the trial court, in contravention of Rule 15a, its liberal policy favoring leave to amend, granted a motion dismissed with prejudice. With regard to the first assignment of error, as the English Court of Appeal has repeatedly held in the cases of Prudential and Edwards, ultravirus is one of the 4 distinct separate exceptions to the false rule. This is settled English law and is binding on this court. American courts have consistently identified the 4 exceptions to the false rule, including the ultravirus exception, as distinctive, using the disjunctive or between each and every one of them whenever they recited the exceptions to the false rule. Now, defendants asked this court to disregard Prudential and disregard Edwards because these cases did not discuss the distinction between past ultravirus acts and ultravirus conduct that the shareholder seeks to enjoin. But this is wrong because this distinction is inapplicable. Now, let's look at the complaint to see what kind of conduct the directors are alleged to have engaged in. In paragraph 7 and 109 of our complaint, and I'm quoting, top executives, including CEO Mark Light, were among those accused of having sex with female employees and promoting women based on how they responded to sexual demands. Multiple witnesses saw Light watching and joining nude and partially undressed female employees in a swimming pool at one of Signet's annual meetings of managers. That's how pervasive the misconduct was. And Mark Light, the CEO of one of the named defendants, was personally responsible for that misconduct. And one of the defendants is chief legal officer. In paragraph 59 of our complaint, we allege that Mr. Jenkins, the chief legal officer, was contacted directly regarding the sexual harassment and discrimination that has been alleged in the complaint. And what did the defendants do? The defendants, number 1, allowed the entire board, allowed Mr. Light to resign rather than terminate him. The defendants made false and misleading statements in Signet's SEC filings, covering up the extent of the wrongful conduct of sexual harassment and sexual discrimination at Signet. So because all the defendants are implicated, directly implicated in the underlying misconduct, there's none of the cases that defendants have cited that are decided by federal district courts would be applicable, because in none of those cases, the board members, all of the board members in those, not all of the board members in those cases have been alleged to have personally participated in the underlying misconduct.
So in your case, all of the defendants are board members?
There are 11 then current board members who are defendants, and yes,
How many?
11.
I mean, how many total board members does Cigna have?
I believe at the time it was an 11-member board.
Okay, thank you.
Now let's look at the several English and Bermuda cases that defendants have cited in support of their argument that the ultra-virus exception has to be considered together with the fraud on the minority exception. The Smith case was not decided on the pleading stage, and the Smith case, the court held that there was a body of evidence that shareholder would approve the excessive compensation in that case that were paid to the officers. The Clark case that was decided by the Bermuda trial court, the portion of the opinion is relied upon by the trial court below here, in this case in dismissing our complaint. That portion of the decision was dicta, because ultimately in that case, the court held that there was no derivative claim at all. The Rosedale case and the Arab monetary fund case, both of those cases are distinguishable, and this is an important distinction. Both of those cases involve third parties rather than the directors of the underlying company. In those cases, the courts decided whether the underlying transaction is ultra-virus as to void them. The idea here is that we are trying to step into the shoes of the company to sue the wrongdoing directors on behalf of and for the benefit of Cigna. In Rosedale and in Arab Monetary Fund, it was a third party involved in the purportedly ultra-virus conduct, and those courts did not find an ultra-virus exception because essentially the courts did not want to stiff the bill to the third party for the wrongdoing of the directors themselves. Now, at the end of the day, the ultra-virus exception is all about whether the underlying conduct can be approved by the majority of the shareholders. We contend that the underlying conduct of sexual harassment and sexual discrimination cannot be ratified by the majority of the shareholders because they are illegal. And we cited the Cochran case that's directly on point. And in the Cochran case, the company was alleged to have paid bribes, arguably in furtherance of the company's business, paying bribes to the military to get contracts for laundry. In our case, sexual harassment and sexual discriminations, they're not only illegal, they serve no business purpose at all. So the Cochran cases are directly on point. The city of Harperwood case that defendants relied on actually supports our position because in that case, the company was alleged to have paid bribes, but the directors of the company was not alleged to have known about the bribes at all. The claim against the directors in that case was a claim of failure to supervise. But the claim that we are asserting here, Your Honors, is a claim that the directors themselves participated or concealed or helped conceal the sexual misconduct that's underlying in this case. So at the end of the day, we think that ultimately our case is distinguishable from every case that the defendants have cited. Now, with regard to the second assignment error, again, we were before the trial court on our first complaint. And the standard review for this court is de novo, because in the Gilliam versus trial case that we cited, the court reviewed the underlying denial of the leave to amend de novo because the denial was based on futility of amendments. None of the defendants said, well, generally the review for denial of leave to amend is subject to only to abuse of discretion standard. That is generally true. But in the cases that these defendants cite, the Asper case, the Riverview case, and the Brewer-Garrett case, all of those cases, the court denied leave to amend based on some sort of factual finding, such as delay or prejudice, things of that sort.
Pause you for a second just to let you know you are now into your rebuttal time. You're welcome to continue. Or
Sure.
I just want
I'll quickly wrap up. The idea is that we made a technical decision, and we did not plead fraud on a minority because we believe, and we still believe today, that the ultra-virus exception is a standalone exception, and we do not need to plead fraud on a minority to prevail on the complaint stage. But even if we are required on remand to plead fraud on a minority, we can do that because in paragraph 118 and 119, we have both pled that the directors are in control of the company, and the control issue is a de facto control. It's not about the arithmetic practice of exercise of counting whether who has 51% of the stock. We have pled sufficient facts to plead fraud because in this case we have pled self-dealing. So, and below, we also made a request in our opposition brief to the motion to dismiss. We argued that there should be leave to amend. So I will reserve time for rebuttal.
I'd like to ask you a quick question.
Yes,
real
ma'am.
quick. In reading the trial court's order, it sounded to me like both sides agreed to Bermuda law applied. In reading your brief, it sounded like you didn't necessarily agree that Bermuda law should be applied.
With regard to shareholder standing, we concede that Bermuda law applies. Whether my client has standing to step into the shoes of the company to sue on behalf of the company on that issue, Bermuda substantive law applies. But I would note that Ohio notice pleading law applies on all considered issues.
Thank you.
Thank you.
May it please the court, Joseph Allergan, on behalf of the nominal defendant, Signet Corporation, and the 14 individuals, past and current directors and officers of this company, that this sole shareholder seeks to step into the shoes of the company and sue. And I'd like to clear up just very quickly, because I think it's very easy, the second assignment of error about the failure of leave to amend to be granted. Your Honors, the controlling law in this district is the Gasper case, which the author judge was Judge Callahan, and Judge Carr was on that panel. It's crystal clear that the standard is abuse of discretion. It's also crystal clear that the person seeking leave to amend must make a prima facie showing that the amendment would serve purpose. What you never heard from my colleague was that the trial court, and it was unusual, not only did we have extensive briefing, we had a full hearing and argument on this motion. The trial court at page 22 of the transcript specifically and directly asked counsel whether or not they could plead fraud in the minority and whether they were relying on that as an exception to the Foss v. Harbottle rule, which normally does not allow one shareholder to take over the reins from the board and the majority as to what's in the best interest of the company. And at page 22, counsel specifically said we are not relying on Foss v. Harbottle, we are not relying on the minority fraud in the minority, and we're not pleading that.
Is Is there a difference between we're not pleading it and we can't plead it?
There may be, Your Honor, but I don't think in this case there is, because first of all, we have the, as this court said in Gaspar, the specter of prejudice. We had fully briefed a motion to dismiss. The court had put enormous resources into this, as did the company and the individuals. And they were given a chance during argument to say, well, we'd like to plead it, or we can plead it. And they chose to stand on a clearly erroneous legal proposition, which 9 out of 9 courts, every U.S. court that has ever looked at the issue of whether you can have standing under Bermuda law to take over a case and stand in the shoes of the company, has rejected their position. Every one. They don't have a single case that supports them, including the Voss decision, where my friends on the other side were counsel. And they conceded if Bermuda law applies, we will not have standing to sue, because under Bermuda law, it follows the Harbottle decision, and it's the company's right. And so Your Honor's question, Judge Callahan, is it conceded that Bermuda law applies here, is critical. Because essentially, if Bermuda law applies, they do not have standing. And I also think that, you know, given the time and resources the court put in on assignment number 2, if you're going to ask for leave to amend, not only should you be clear about what you're trying to amend, they did the opposite. They said, we're not going there. And so I think there's no assignment, certainly under an abuse of discretion standard, under this court's decision in Gaspar, about the trial court's decision not to allow an amendment. And by the way, there was no motion to amend. There was no pleading that was attached. It was actually a one line at the end of their brief opposing our motion to dismiss, which raises, obviously, the specter of prejudice. Now, going to the main issues in the case, what's so frustrating, and I'm sure for the court, is that the case hasn't been accurately described, and ultimately the trial court got it. This is not a case involving sexual misconduct, sexual harassment. Frankly, it's outrageous what was done in the pleading here, to blacken the names of 14 individuals who have served on this company's board or as officers, based on alleged allegations, not that this plaintiff has uncovered, just copying pleadings from other litigations where the company is defending itself. There hasn't been a single finding in any court against Mr. Light for sexual misconduct, against Signet, board of directors. And very importantly, Your Honor, I hope I can explain this correctly, the claim that's being sought to be asserted here is a breach of fiduciary duty. It's not sexual misconduct. What the plaintiff is saying is that these 14 individuals who served on the board of the company or as officers of this company didn't do their job and allowed a supposed culture to take place where misconduct occurred, or that they improperly promoted Mr. Light, or that they turned a blind eye. The case they want to bring is breach of fiduciary duty. But their problem is that Bermuda law is crystal clear, and the court got it 100% right as a matter of law at the trial court and as a matter of policy. What is Voss v. Harbottle? I mean, it's hard to argue about an 1840 case. It doesn't happen every day of the week. But it's venerable. It's stood the test of time. What it's saying, Your Honors, is a corporation has to run by majority rule. Signet has 10,000s of individual shareholders. There are tens of millions of shares that are trading in Signet right now as we're speaking on the New York Stock Exchange. You don't get because you own one share and you have a plaintiff's attorney come in and say, I think we can do a better job than the board of directors in deciding what claims to bring or not, what cases to defend or not. That's what they're trying to do. They want to take control from the board and bring a case, which, by the way, put aside whether the claim has any merit, Signet's defending these claims or addressing them, resolving them, whatever. That's the job of the board. Can you imagine if one shareholder could come in and assert a claim against directors, which could potentially lead to liability for the company in underlying cases in other jurisdictions that it's defending. It would be chaos. And that is why the rule has stood the test of time. Now, everyone agreed below that Bermuda does follow Foss v. Harbottle, and that the normal rule in Bermuda is very clear. You cannot bring a claim as an individual shareholder which seeks to recover damages in the name of and on behalf of the company. As my colleague said, to step in the shoes of the company and essentially assert their claim, unless you can have very narrow exceptions. 9 out of 9 U.S. courts that have looked at Bermuda law, British Virgin Islands, any jurisdiction that follows Foss v. Harbottle has denied standing. So what is their argument they tried to assert? There is a narrow exception for an ultra-virus act, which almost brings us back to our law school days, because you rarely hear that anymore. And the reason you don't hear it anymore is most corporations have the ability to do anything they want to do under their powers of association. And I'm not arguing that corporations can violate the law or act with impunity or sexual misconduct should be condoned, but that's not ultra-virus. And what the Bermuda cases have said, Clark, and what the Tyco case says, it was an MDL case in the federal court, the Wing case in the Southern District, all the cases that the trial court cited said if there is a potential ultra-virus act that the company is going to commit, and it hasn't been committed yet, a shareholder can step in and ask for an injunction. It kind of makes sense. If you know the company is going to do something it doesn't have the power to do, even though you're distinct from the company, you can enforce it. But if it's a past act, like here, and they're seeking damages on behalf of the company, then you must prove the fraud on the minority exception. That's what Clark says. In re Tyco, 2004, Bermuda courts have recognized that to recover damages for past ultra-virus acts, the shareholder must demonstrate that the case qualifies under the fraud on the minority exception. Wing v. Schaefer, 2007, Southern District, my home court. All the acts relate to past conduct. To invoke ultra-virus, plaintiff must meet the requirements of fraud on the minority. And the cases go on and on. Not one case goes their way. The reason they conceded they couldn't plead fraud on the minority and why an amendment would be futile is because they can't do it. Who controls Signet's board? The shareholders. You know how many shares this one individual shareholder who's coming to court has? I don't know, but it's certainly not 50% or anywhere near it. It's a sole shareholder. The majority controls. There's no argument that the defendants, alleged defendants in this case, even themselves, the directors, either are a majority of the shareholders, they're not. They're serving as directors, or that they perpetrated a fraud. The only cases that are allowed to proceed is if the majority stole, misappropriated, took money away from the minority, and then you could see why the minority who was injured might have an ability to step into the shoes of the company. We don't have to go there, Your Honors, because that's not, they conceded at page 22 of the transcript that they could not plead that case. So in closing, unless the court has questions, I just want to bring it back to the really important corporate governance rule, frankly followed in all American courts and also in Foss v. Harbottle and in Ohio, and the incredible damage that would be done if the trial court's very deliberate, informed decision was reversed. It would really be saying that any one shareholder who hires a plaintiff's attorney can come in and bring a lawsuit in the name of the company against the sitting directors and officers or formers who are normally protected by the business judgment rule, trying to do the best they can under sometimes very difficult circumstances. I could tell you a lot about Signet, the company, that women comprise actually the majority of the executive suite, including the CEO, the general counsel, the chief financial officer. But this case isn't about sexual misconduct, which is the hook they tried to use below. It's about whether or not you can sue in the name of a company under Bermuda law for breach of fiduciary duty as a sole shareholder. And the law is crystal clear, you cannot, 9 out of 9 cases in the federal court. The trial court gave them every opportunity, full briefing, full argument, and she got it 100% right, both as a matter of law and as a matter of sound corporate governance policy. Thank you very much. Thank you for allowing me to appear pro hoc with you today.
We have a little over 3 minutes left.
There's been no concession below that we will not repeat and in the amended complaint to allege the fraud on minority exception. The only thing that we did was that we said with the initial complaint, we did not wish to plead fraud on minority. And I want to get that straight. There's no waiver, and at the end of the day, if you look at the trial court's decision, the trial court explicitly said that I am denying the motion for leave to amend. The procedural posture of seeking leave to amend was sound. There's no prejudice, and defendants have cited none. That holds for the proposition that there's prejudice to the defendant just because they briefed one motion to dismiss, and somehow there's sufficient prejudice to deny leave for leave to amend in that context. If you hear my friend's argument about futility, all he was saying is that one day somehow you need to get 51% of the shareholders on your side to plead the fraud on the minority exception. That is not true because the typo case that defendant side says so. The pleading of control is de facto control. It's not about the numbers game of 51% versus 49%. Sexual harassment and sexual discrimination misconduct underlying this lawsuit is egregious. We have submitted to the trial court 1,300 pages of declarations from 249 individuals. The underlying sexual discrimination arbitration certified a class of 69,000 members. And I'm quoting the federal district court overseeing the securities for class action in the Southern District of New York. The court said, quote, pervasive sexual harassment reached the highest offices in Signet, end quote. We are trying to hold the wrongdoing directors liable for their wrongful misconduct in this case. In terms of policy, Your Honors, we all know that Signet is one of the largest jewelers in the world, running 3,600 stores worldwide. Not one store is in Bermuda. The only reason why we're here today is that Signet is incorporated under Bermuda law. Now, it's not an exaggeration at all to say that Signet's connection to Bermuda is paper thin. In the face of egregious wrongful misconduct, going all the way up to the CEO, the defendants not only have they done nothing to control it, they also made false and misleading statements in the company's public disclosures to cover up the extent of the wrongful conduct. This court, just like the trial court, is sitting in equity. This is a shareholder derivative litigation, and under equity, for every wrong, there should be a remedy. And the complaint below was dismissed at the pleading stage with no discovery, and we think that it's inequitable, and that's why we